Good afternoon, my dear friends. Recently, we had the opportunity of working for CCA approval in relation to a mega merger of 52 companies, 51 companies with one company. Section 5 of the Competition Act considers all sorts of acquisition of rights, controls, combinations, and there are two different methods of understanding requirements. One is about the size. Irrespective of size, you have to notify, seek clearance. But there is a financial threshold basis which you are supposed to make application. The Competition Commission of India is a very excellent, efficient, beautiful body which does not go with any suspicion that their combination is going to be harm to competition. They don't go with any preconceived notion that there will be appreciable adverse effect on competition. All that information is being provided to the commission by the person who is giving the notice. Of course, it has powers to inquire, investigate. That's a different subject altogether. Like our collective investment schemes under the SEBI, there is a financial threshold of 100 crore. By whatever be the scheme and arrangement, you notify. You don't really feel that it is a collective investment scheme. Yet, if there is some pooling of funds from investors and a large body of people, you will always think that it is not a collective investment scheme going by the ingredients. But you don't need to leave it at that because there is a financial threshold. Similarly, in the CCA regulation also, if the financial threshold is giving you an information that you must notify small enterprises, less than small value and all, there is no need for notification. The notification part of the CCA is a very well structured, format driven approach. You need to have a study of that in depth. The information that you are providing in the notice is a very structured and very important, honest disclosures about the entire aspects of the transaction you should give. It is not about the legal effect of transaction. Whole lot of information must be provided so that they are able to see there are overlaps, horizontal, vertical methods, steps, how this combination will take place, when it will take place, through what are all the various modes and means. Everything must be studied, everything must be informed, everything must be notified. Ultimately, harm to competition test is not directly applied, but based on the information you will be with further information that they may seek, you will be able to find how CCI views it. That is important. The adverse effect on competition, appreciable adverse effect on competition. Is there a material risk to competition? Are we providing an opportunity through this combination to cut down the competition from the market? Entry norms, or are they going to be create difficulties for the entry? All these things are subject matter of the understanding the notice and the information that you furnish. For example, if the information furnished is full, complete, however, yet the CCA has powers under section 29, read with rule 5.4, to ask for the regulation 5.4 to ask for further information. They will study whether there are any overlaps and whatnot. So information that you provide should be complete, comprehensive, full, complete, honest disclosure should be made. In addition to that, they will ask you information. They have power to request for further information and you are liable to provide the same. This entire structure you will know only when you do the transaction, the clearance, approval process. Then only you will understand that. What are the ways in which things are being looked at. We look at from a very plain, simple way. But the authorities on competition, how many competition cases they would have done. So they look at from that angle. granular as well as wholesome. That is a very beautiful feature. One thing which I wanted to tell was about the matter of analysis. When they look at this, they look at whether there is going to be any acquisition. For example, if a person may be acquiring a 25% control only, however, he would have had a lot of clauses whereby even an annual business plan of the company cannot be cleared until this guy approves it or provides consent. Similarly, they may inquire into see whether there are going to be some structures through imports, whether there are going to be any points like there is a important thing which I want to tell you. They say, I will read it. Extent of barriers to the entry into the market. What are the barriers? Generally, in the relevant market relating to your goods. Degree of countervailing power. For example, the consumers may be large retail stores or government organizations. So they will have their own influence. They will be able to mitigate it. You cannot play with it and manipulate it, because even if you are having a high market share, because the consumers are like that. So it is not going to be so easy for you to manipulate it. So structures will help mitigation or make it difficult to create an adverse effect on the competition. They will check the vertical integration. They will check the possibility of a failing business, possibility of innovation, whether it is blocked or it is going to come, possibly a flow of funds into the stream of production, like that. This is another thing which we need to look at is the object of the provision. What is the object of this provision? It is placed before the CCI, and CCI will look at what is happening there. Is there any appreciable adverse impact on competition? Now, when you look at the power of CCI, they look at whether a combination has caused or is likely to cause appreciable adverse effect on competition. The underlying premise is only that. And for example, one thing I wanted to read and tell you is the combination situations, the business transactions, when you give the information, it is not about legal form. You should provide all the intended purposes, how it is going to operate. Whether it is going to be implemented through, for example, in our case, we are implementing it through a scheme of amalgamation, single scheme of amalgamation. It has got its own Companies Act formalities and other sector regulator formalities. So intermediate structures, multiple agreements, instruments, sequential steps. What is a merger control framework? How it is going to be achieved? That information is what is more important for the CCI to decide. Then CCI passes orders. So objective of the cumulative effect of the proposed effect of the adverse effect or effect on competition, ultimately it will be decided whether it is harming to the competition or harm to competition is not there. So to understand the ultimate objective, is it harm to competition, a big procedural aspect is being done to collect information, to go through that in a granular way, in a slices like a CT scan, 128 slices, and thereafter they form the opinion and then give your approval. So this is the background in which CCI work has to be undertaken. These provisions like Section 5, Section 6, the Regulation 29, 20, all these things, we should understand from that perspective. Then only the quality of information you provide, the completeness of information you provide, the usefulness of information you provide will be seen by them. And if is there any information they want more, they will. I would like to reiterate once again, it's a most efficient, clean, beautiful body, and by nature they will not go with any suspicion that this is something else. That is not the way the CCI approaches. Thank you, my dear friends.